Ladies and gentlemen, and welcome to the Knowledge Group webcast, Anti-Money Laundering, Practical Guidance for Managing Regulatory Compliance in 2016. I'm Sal Giangrasso, your moderator for today's event. And before we begin, let's go over a few housekeeping notes. Please note the FAQ.help tab located to the right of the main presentation. On this page, you'll find answers to the top questions asked by attendees during the webcast, such as how to fix audio issues, where to download the slides, and what to do if you miss a secret word. To access this tab, click the FAQ.help tab to the right of the main presentation, and when you're done, click the tab of the main presentation to get back. For those viewing the webcast on a mobile device, please note these instructions are for Apple and Android devices only. If you're using a Windows tablet, please follow the instructions for viewing the webcast on a PC. The FAQ.help tab will not be visible on mobile devices. You will receive the frequently asked questions and other pertinent information through the app's chat window function on your device. On Apple devices, you must tap the screen anywhere to see the taskbar, which will show up as a blue bar across the top of the screen. Click the chat icon, then click the chat with all to access the FAQs. Feel free to submit questions using the questions function built into the app on your phone, and you may use your device's pinch to zoom function to enlarge the slide images on your screen. Headphones are highly recommended, and in the event of audio difficulties, a dial-in number is available and will be provided via the app's chat function on your device. To all of our attendees, please follow us on Twitter. That's @KnowGroup to receive updates for this event, as well as other news and pertinent information. Speakers, I give these secret words out at randomly selected times, and I may have to break into your presentation briefly to read a secret word, so in advance, please pardon the interruption. Now, attendees, I'd like to take a moment to tell you about our two unlimited attendee programs, free and paid. Free Unlimited will give you access to all the course material for all live events. It's a terrific research tool, and it's free of charge. Paid Unlimited will give you access to all the materials as well as free registration for live events and free certificate of attendance processing. You'll also be able to invite your clients to events free of charge as your guest. And if you sign up today, you'll be able to enroll in our Triple Play program, adding 2 of your colleagues from your company to join your unlimited plan for free. That's 3 for 1. We have a 6-month plan for just $499 all in, and there are other options available. So sign up today for the Triple Play discount and other extras. And you can read about all the benefits and additional savings on slides 4 and 5. And you can register via the sign-up sheet or registration link included in the post-conference surveys email. Any questions on this, just send a note to info@theknowledgegroup.org with unlimited in the subject. Now, I'd like to take a moment to thank our participating partner firms for this event, Pneuron, Reed Smith, and Texas A&M University Law. Please feel free to visit their respective websites. Now let's introduce today's speakers. Simon Moss is with us. Simon Moss is the Chief Executive Officer and Board Member for Pneuron Corporation. In his role, Simon is responsible for overseeing the management, strategy, and operations of the business on a global basis. And under his leadership, the company was founded, capitalized, and the strategic platform developed, transforming Pneuron into a global technology provider. Joining him on the panel, Kathleen A. Nandon. Kathy Nandon is co-chair of Reed Smith's Anti-Money Laundering and Trade Sanctions team and a member of the firm's Global Regulatory Enforcement Group. She advises clients in a number of industries, including the financial services sector, on the conduct of internal investigations, anti-money laundering, and Bank Secrecy Act requirements, federal asset forfeiture, the False Claims Act, the Financial Institutions Reform, Recovery, and Enforcement Act, subpoena compliance, trial preparation, and other law enforcement-related concerns. And rounding out today's panel, Professor William Burns, Texas A&M University School of Law. Professor Burns is Associate Dean of the Texas A&M University School of Law and is one of America's leading experts in the global battle against money laundering. Professor William Burns is the lead author of Money Laundering, Asset Forfeiture, and Recovery and Compliance, a Global Guide. And we would like to thank these speakers that have been very generous with their help and support preparing for this event. I would also like to thank the attendees for carving time out of your busy schedules to join us here today. You know, attendees, you have a unique opportunity to interact with this terrific panel of key thought leaders and experts, and I encourage you to ask questions for use during the Q&A section. Just use that chat window, lower right-hand corner of your screen, type in your question, submit, and we get to the Q&A in the final 15 minutes or so of the event. So once again, thanks to all for joining us today. And now, without further delay, we can begin our event. Speakers, to advance your slides, please remember to say next slide at the end of each page of your presentation. And to advance any animation, please say next point for a single animation, or say build the slide out if you want all animated points to be displayed at once. So wait here as we take a moment to switch the media to accommodate animation. In the meantime, I would like to remind Mr. Simon Moss that he's our lead-off speaker. And Mr. Moss, you will have 30 minutes to present, which should take you to about 38 minutes past the hour. So if you keep that in mind, we hope you can comfortably include all of your comments by then. And now, Mr. Simon Moss, let's please begin, and let's everyone please turn to page 14. Go ahead, Mr. Moss. We seem to be having a problem. Perhaps the line is muted there for Mr. Simon Moss. Let me just check in with our other speakers, make sure.
Hello, I'm here.
Okay, Mr. Moss, please go ahead. Return to page 14.
Oh, good. Thank you. And apologies for the snafu. I will try to keep it at 30 minutes. So welcome, everybody. We appreciate greatly you investing the time to meet with us all. I'm sure Kathleen and Bill will be significantly more entertaining than I will, but I want to take about 30 minutes of your time to really talk about what's happening at the coalface. We're dealing with anti-money laundering programs, BSA programs, tax evasion, and internal malfeasance programs on a regular and daily basis in the deployment of our technology. My background is very much intelligence anti-money laundering. I was intimately involved with building and then selling a company called Mantis, which was a transaction monitoring system. And we spent most of our time looking for specific categories of money laundering. We were not, and this is really the genesis of many of the challenges that the anti-money laundering program has these days, we were not looking for a needle in a haystack. Rather, we were looking for needles in a stack of needles. People that wanted to look normal, did not want to look innocuous, did not want to be an outlier, and wanted to deliberately undermine the analytical and algorithmic techniques that we were using to try and find them. So if we could move to the next slide, I think what we've seen is an evolution in, if we could just click through into the first challenge, we're looking at really 3 challenges. And I think, you know, Time Magazine did a front cover in 1989 and said that money laundering was a $1 trillion problem. We've spent close to $800 million trying in technology and processes and deployments and regulatory reaction to try and deal with it. It's still a $1 trillion problem. It's evolved, though. It has become more sophisticated, more incestuous. This isn't a simple guy running velocity or structuring or $10,000 transactions to try, or $3,000 transactions to try and keep it under a $10,000 limit. These are individuals that have put together very significant and complex approaches to laundering money through the financial system. But the essence of how they do it has not changed. They are effectively focusing on disorganization and opacity in the financial process, both the individual financial institution as well as systemically across financial institutions. So we're going to focus today on ways that we have found people doing interesting money laundering and the key areas of focus that money laundering activity is really focusing on to try and undermine the investments that we've all made into this business. The first is the transaction monitoring system. Now, there are companies like Oracle Mantis, my old company, Actimize, Detica, which is the old Norcom guys, Fiserv, multiple other firms that provide terrific algorithmic approaches to identifying behaviors. I said earlier, though, that they're not looking for a needle in a haystack. They're not looking for an anomaly. That would be a money launderer who ends up as an anomaly, as an outlier. Frankly, he's a bit of an idiot. What they're looking for is they're looking for a needle in a stack of needles. We're trying to find people that look exactly the same as everybody else. And so the problem with the transaction monitoring system, despite these fantastic investments that we've made and the progress that the algorithms have made, is that we're still generating massive amounts of false positives. In the 90 to 95% range of all alerts generated by a transaction monitoring system is a false positive. What that means is we've kicked the problem down the workflow into the FIU, into AML operations, in which large amounts of people are desperately trying to analyze huge amounts of alerts, 95% of which are false positives. So as a money launderer, if I can look fairly innocuous, I can actively participate in the false positive environment because I have a 95% chance of never being caught. And I think that's a fundamental challenge. And so many money laundering activities are really looking to build very innocuous profiles prior to moving into the real money laundering activity. Indeed, we've heard of 18 to 24 months of just regular, normal, perfectly legal activities, and then a transference of that behavior to money laundering. We've heard of several areas where money launderers are actively looking at the dependent variables within the algorithms and looking at the predictors, and then really trying to see how they can make sure that they are not identified as an anomaly when those regressive algorithms have run. And so what money launderers are doing is they're investing a lot of money up front. They're investing their margin, in other words, up front to try and generate as much innocuous legal activity as a profile before they then move on. And that's often an 18 to 24-month investment that they make into that business. The second area, which I think has expanded a little bit, is these new community-based transaction types. They're fascinating. I think online casinos has received a significant amount of profile, but the whole concept of digital fundraising and charities, particularly aligned with prepaid credit and prepaid debit cards, has opened an enormous opportunity to move in large amounts of money into the financial system without the diligence that other transaction types. And I think the whole concept of digital retailing, white goods, cars, other elements like that, are also a fascinating area that we need to focus on much more efficiently and much more effectively. It's a little bit on the horizon, but I would suggest that I would suggest that the primary focus that we have is on the current volumes of alerts being generated, but there are new digital transaction types that I think are going to be coming to hit us fast and quick. The second area, if we could just move on to the next point, the second area is really just to continue to exploit the whole diversity of the global financial enterprise, specifically understanding your customer. We continue to have inconsistent onboarding and customer awareness processes, different lines of businesses, different jurisdictions, different approaches on how risk is measured across the enterprise is exposing us to significant anomalies in the way that we assimilate and understand our customers. We're going to drill on that a little bit later. Obviously, jurisdictional abuse, the Panama Papers are all over the news at the moment. I think that's a fascinating challenge. I'm not going to drill into this. The third area, if we could move on to the next slide, or the next point, is really just sort of a general catch-all that anti-money laundering, as with regulatory compliance in general, has a challenge in being able to access, analyze, and integrate huge amounts of disparate and diverse data, both internal and external. Many people talk about anti-money laundering as a big data challenge. It isn't. Let that sink in. What it is a diversity and distribution challenge. It only becomes big when we are all forced to move all of that heterogeneous data into some giant data warehouse. And 80% of an anti-money laundering project is not spent in finding money launderers. It is spent in identifying, normalizing, moving, storing, and optimizing data in some sort of central construct. Indeed, from a client master perspective, understanding our customer for KYC, for 360, for credit risk, for onboarding, most financial institutions have done 5 projects in the last 3 years, and each one of them have been exactly the same. Money launderers exploit that disorganization, that diversity in data, that difference in processes and assimilation. And it is important to be able to recognize that the core to an anti-money laundering program is to establish transparency through uniformity in the way we assimilate clients, in the way we analyze alerts, and most critically at the moment, in the way that we investigate them. If we could move to the next slide, I'd like to drill into those 3 points. This is a common FIU or anti-money laundering program. The current process takes to generate or investigate an alert from any transaction monitoring system. I happen to be a big fan of Mantis, of course. Actimize is excellent. The old net economy guides under Fiserv has some very good stuff in it as well. But they generate huge numbers of alerts because they're finding it very difficult to find these anomalies, because money launderers are becoming much more intelligent in the way that they fall into the false positive noise. And so the transaction monitoring system is desperately trying to find the wood for the trees. It is unfortunately sending huge amounts of trees into the FIU. And so, as I discussed, 95% of alerts are actually false positives. They take about 45 minutes to analyze. The interesting thing is that 20% of that time is investigation. The rest of it is data access and data calibration, understanding your customer, getting risk model information, getting EDD and KYC information, getting additional transaction history information, now going outside and getting career information or social media interaction information into the likes of LinkedIn and social. So we're dealing with an ever-expanding diversity of data sources, all being driven into one single business unit. So the question is, how does the anti-money laundering program, without having to remove any of the systems that they have, which are great investments in transaction monitoring systems, great investments in case management systems, how do they deal with this fundamental problem, which is the time it takes to access, analyze, and interdict alerts and cases? And if we could move to the next slide, because it is in the noise that our hypothesis and others that we've been talking to see the money laundering activity happening. It is in the 95% of false positives, in innocuous activity, that the money launderer is now settling. And it is there that we have to focus. The only way to achieve that is to improve the productivity of the investigation. The only way to achieve that is to break the back of this monolithic approach to accessing and analyzing data. With our clients, and if we could click the next button, what we have done is we put a fabric in place. I won't go into the technology. Do feel free to go to the Pneuron website, Pneuron.com, and look under use cases under financial crimes. Within a 4-week period, we had put 50% productivity into the client's FIU. How? Well, we automated the access to data, pretty straightforward. Google Negative News, LexisNexis, WorldCheck, other elements. But we then were able to allow the client to calibrate that data. So negative news information may be more important relative to an individual, whereas a high-risk entity alert, PEP screening, and sanctions information would be more important. And so the analysts now will work with their existing case management system, but they have moved a 45-minute process of data access, investigation, and interdiction to about 5 to 7 minutes, with no incremental changes to the existing investments that they've made. It is only in this way that we are going to be able to deal with the massive amounts of alerts that transaction monitoring systems are generating and the deliberate exploitation of those alerts by modern money launderers. The second area, if we could move to the next slide, is, as I talked about, was really the degree in which we understand and look at our clients' risk. Traditional risk models are fairly straightforward approaches. They really do look at a limited amount of data. They tend to look at the predictive behavior expectations, and they tend to use the data calibrated from the KYC or onboarding documents as the primary analysis against assimilation or accepting the customer's business. And secondly, analyzing the customer's behavior, for example, deviations in expected behavior within the transaction monitoring system. But if I'd set myself up to be, a pretty standard, straightforward guy, and I behaved myself for 18 months or so, it is very difficult for the risk model to change and understand a deviation in my behavior. The only way to do this is to, again, deal with a diversity and distribution of data problem by accessing more data sources and importing them and using them as part of the risk model, both in assimilating and onboarding the client, and if we could go to the next slide, as well as on an ongoing basis. Oh, yeah, please.
If I could just cut in for the first secret word. It's money, M-O-N-E-Y. Money is secret word number one. So if you're seeking continuing education credit, please jot down money as the first secret word. And as a reminder to Simon, you have about 18 more minutes to present. Just wanted to give you that time check, okay?
Yep. Great. I can bore everybody for the rest of this period. However, so the current client onboarding models and risk models take a limited number of data sources. They are excellent, by the way. There's no criticism to the algorithmic approaches that they're using, but they have a limited amount of data sources primarily because the data sources are highly distributed, highly diverse, in different technologies, in different sources, and the model that we have used in the past has been to try and move all of that data into one place before we can actually use it. So what Pneuron is doing, and what we're doing with our clients, is we've put another network in place that allows our clients to bring in negative news information, bring in associations and corporate actions, organizational structures, credit and other risk models that are used, particularly CCAR, peer analysis. If I say I am a salesperson, what is the expected behavior, expected use of funds and other elements like that. And also, most interestingly, social behavior, my career path, information in LinkedIn, my contacts and people that follow me in Facebook, etc. For example, I live in New York City, and I'm a pretty innocuous guy, but there seem to be lots of people from Colombia and Venezuela that seem to be following me on Facebook. Those are really intricate, interesting questions that allow the customer, or allow the financial institution or the enterprise to truly have a clear understanding or clearer understanding of who I am, what I could do, and what is the potential risk that they are accepting when they take my business. It is more complex. It will absolutely change the way the risk model works, but it is significantly more transparent and, most interestingly, highly leverageable. The ability to clearly have a very solid, understood, empirical multi-data source input into a risk model is a highly leverageable asset across multiple other business problems, not just anti-money laundering, but credit, default, propensity to buy other products, consolidated billing elements, multiple areas within the whole customer relationship continuum can be leveraged and actually be used to generate significant profitability, whilst at the same time applying strong transparency into understanding your money laundering risk. So those are two elements that I think are fundamentally important to how anti-money laundering businesses are moving forward, to be able to be much, much more effective in the investigation units by applying true productivity into the way data is accessed, analyzed, and used to dispose of alerts and cases. And the second is the beginning of the anti-money laundering process to apply much more consistent, much more broader data sources into the risk model. So we have a true 360 view of the client now, of the client's expected behavior, and of the client's ongoing behavior relative to multiple different indices. Now, what undermines all this? If we could just go to the next slide. We deploy anti-money laundering solutions as we deploy all regulatory solutions in the same way today as we have done for 30 years. It requires us to bring the data to the analytics through multiple sources, and they could be, as you see here, through huge amounts of manual processes, or secondly, through the best-of-breed approaches using a giant data warehouse or a data lake with an ETL tool and lots of different layers of technology. In other words, lots of slices of bread prior to actually get into what is part of why you're actually doing the project. And as I said, this is no different for anti-money laundering than it is for any regulatory report. Indeed, most clients have multiple projects like this all running at the same time. And yet we are looking at exactly the same operational data. We are looking at exactly the same clients. But for some peculiar reason, despite that, we have not been able to put in place a regulatory and anti-money laundering ability to look at risks as merely lenses onto our operating systems, onto the topography of our data, onto the behavior of our clients. Instead, we treat them as completely different silos of projects. And this is incredibly easy to exploit if you're a money launderer. It is the way that we are organized and that we focus our technology and processes to deal with heterogeneous data, to deal with diverse technology and diverse customer relationships, that is undermining our ability to catch money launderers the way that we would like to, and keeps us at the trillion-dollar problem that Time magazine talked about in 1989. But there is a better way, and I'm going to sort of plug Pneuron here a little bit for the last couple of minutes, and I apologize for the fragrant plug-in of my company. If we could go to the next slide, and we could build this. Just imagine being able to apply a network or a fabric over the top of all of your systems, your databases, your customer onboarding systems, your CRM systems, your transaction monitoring systems, your case systems, in a completely non-invasive way to pick and choose data that is relevant for the investigation or the report or the regulation that you need. You're not going to move all this data. Instead, what you're doing is you're fundamentally changing the architecture of your regulatory and AML reporting. Instead of moving the data to the analytics, you're doing the reverse. You're moving the analytics to the data, and you're orchestrating intelligence. You're orchestrating reports, analysis as a fabric, as a network of functionality. In other words, your reports, your analysis, your investigation is now a lens looking at all of the data sources. So your ability to assimilate new clients goes through a single risk model lens that brings in multiple other external data sources to ensure that that risk model is profoundly powerful at providing significant transparency into the expectations of the client, into the diligence on whether the client is telling you the truth, and into the ability to see whether that client is actually going to do what they say they're going to do moving forward. The ability to access multiple different data sources in real time so that investigations and the acquisition of data can be done when you hit the case on the case management screen, rather than having to go to multiple other systems or go to a giant database and try and dig out and fathom what you need. And also, at that point, to build new analytical approaches, new algorithms, putting cognitive intelligence into what we call neurons, and allowing you to run predictive anti-money laundering activities, allowing you to do the risk around the Panama Papers in 2 days instead of the usual 6 to 8 week, several month activities that you've been used to in the past. Taking this one step further, if we could click the button again, it doesn't just stop at anti-money laundering. You can then begin to say, well, hold on a minute, FATCA is essentially looking at exactly the same clients. I'm just asking a slightly different question. Instead of are they money laundering, it's what sort of assets do they have offshore so our friends at the IRS can tax us. Basel III is looking similarly. Dodd-Frank, CCAR is looking similarly at the same operating and customer data, and yet at the moment we are deploying multiple redundant and repetitive projects to understand this risk. And it is this breakdown in uniformity in the way that we access and analyze that money launderers are exploiting on a daily basis. Whether they are setting themselves up in innocuous behavior through the KYC system, or whether they are hiding in the huge amounts of false positives that the transaction monitoring system is creating, because they are fully aware that it is taking 45 minutes to 2.5 days to analyze alerts and cases, that they have a high probability of never being caught. Something has to change. We have spent multiple millions of dollars, multiple billions of dollars trying to resolve this, but we will always undermine ourselves because we have a highly diverse and distributed set of firms, and the way that we are trying to integrate all of that is no different today than it was 30 years ago. What I'm delighted to say with Pneuron and our customers is we're bringing a whole new approach to it, and we are improving our clients' anti-money laundering businesses, particularly in the FIU, the deployment of integrated and more complex and more comprehensive risk models by up to 50 to 70% of the existing productivity, or 50 to 70% improvement in productivity, and at a fraction of the deployment and operational costs of the past. So thank you very much for allowing me to talk this through. I hope at the very least we piqued your interest. What Pneuron tends to do when we meet people, it tends to stimulate a ton more questions, some healthy skepticism. We are delighted to entertain any of that, and we look forward greatly to receiving any phone calls that this webinar might create. Look forward to any questions towards the end of this webinar. And with that, I'd like to say thank you very much for your time, and look forward to hearing what my colleagues Kathleen and Bill have to say.
And thank you very much, Simon Moss. Please do stay with us for the question and answer session. And to the attendees, you have that chat window on the lower right-hand corner of your screen, and you can use it at any time during today's webinar to type in a question, submit, and we get to the Q&A in the final quarter hour or so after all of the presentations are complete. We do hope that Simon Moss will stay with us for the Q&A. Now let's do secret word number 2, and we'll move on to our next speaker, Kathleen Nandon. Secret word number 2 is data. D-A-T-A, data is the second secret word, so please jot down data. Secret word number 2, so you can get your continuing education credit, attendees. Data is secret word number 2. We're going to keep the conference rolling now, and Kathleen Nandon is ready to go. Kathleen, you too will have your fair share of time. Let's figure a half hour. Take it up to about 6 minutes past the top of the hour. And Kathleen, please go ahead.
All right. Well, thank you, and thank you everyone for listening in. I am hardly entertaining, but I'll do my best to keep you all awake over the next 30 minutes or so. I come at this topic largely from an enforcement perspective, having spent almost 13 years as an assistant U.S. attorney, most of that time in the office's forfeiture unit, where I focused on money laundering investigations, prosecutions, and asset seizures. So I'd like to spend my time this afternoon covering 4 topics related to enforcement in the Bank Secrecy Act money laundering area. One, I'd like to briefly introduce or discuss the Bank Secrecy Act. Second, I'd like to talk about principles governing prosecution and charging decisions. I'd like to touch on individual liability, and then end by discussing some practical takeaways, lessons learned. What can we do? So next slide. I am not going to spend much time on this overview of the Bank Secrecy Act, as I suspect that most folks here on the audience are already familiar with it. However, because some of my later remarks will flow from or assume some familiarity with the statute, I do want to pause now to hit some highlights. First, though, I want to make sure that I define terms, and I want to define money laundering, at least how I'm using the term money laundering. And at the risk of grossly oversimplifying, and I do mean grossly oversimplifying, money laundering is essentially a financial transaction with criminal proceeds and with the intent either to promote the ongoing illegal activity or to conceal it. And if those of you who are familiar with the money laundering in the U.S., you're rolling your eyes going, yeah, Kathy, but there's lots of exceptions. That depends on the jurisdiction that you're in, state or federal. You can transact with the proceeds of certain tax offenses and not commit a federal money laundering offense. You can conduct transactions, international transactions with so-called clean money and still commit federal money laundering offense, so on and so forth. That is all correct, but I really just wanted to make sure that I stop for a moment to say how I'm using the term as we go on here today. The second thing I want to note is that the Bank Secrecy Act, its very title is frankly a misnomer. Instead of promoting secrecy, the Act really codifies the proposition that banks and financial institutions are the gateway to the U.S. economy, and Congress therefore imposed upon these institutions certain obligations and reporting requirements, i.e. non-secrecy. Next slide, please. Section 5318 of Title 31 of the U.S. Code imposes obligations upon financial institutions that are familiar to us all. The last one, the requirement to maintain an effective AML program, requires a little further comment. Next slide, please. And needed so much further comment that Congress, in fact, spelled out the bare minimum requirements for an AML program. The program must have internal policies, procedures, and controls. You have to have something. There has to be something there. There has to be a compliance officer. There must be someone overseeing the program. There needs to be ongoing employee training, and there needs to be an independent audit function. Next slide, please. This slide really provides specific statutory citations for some of the requirements that I've just mentioned, so I'm not going to say much more about that. Next slide. In addition to federal law, we've got the FFIEC manual. The FFIEC manual, for those of you who don't know, is FFIEC stands for Federal Financial Institutions Examination Council. That's basically the bank regulators. It includes the Federal Reserve, the FDIC, the OCC, and others. And those organizations have published a manual to provide guidance to examiners carrying out AML examinations. The manual includes these requirements that are on the slide, and again, which are familiar to the anti-money laundering community. I just want to make a couple quick points about that. First, the regulators recognize that there is no one-size-fits-all approach to AML, and they are advising institutions to create programs that take their specific risk profiles into consideration. For example, the small retail bank in Middle America faces very different risks and therefore should have a very different AML program than, say, a large international bank with international clients or significant correspondent banking relationships, or to a brick-and-mortar bank that's operating near the southwest border, or so on and so forth. The idea is You must look at your risk profile and design your own program. The last two bullets on this slide, that there should be a qualified compliance officer who's given authority and autonomy and also the resources to do his or her job. You may question whether that even needs to be noted, but a review of recent enforcement actions really does highlight that this appears to be a continuing problem, particularly for smaller organizations, and it's particularly apparent when you review enforcement actions, particularly those brought by FinCEN against MSBs, money service businesses. Next slide, please. So before we get into the specifics of prosecution under the BSA itself, I think it's useful to spend a few minutes discussing principles of prosecution generally. In other words, what considerations are supposed to go into the decision-making process? How is the sausage made? Next slide. So on this particular slide, I've got three different bullets and three different links for those who are interested in doing some further reading. The first bullet contains a list to the U.S. Department of Justice's general charging considerations. And I've included that there really for your information. I'm going to focus on the next bullets, which are links to DOJ's and the Manhattan DA's guidance for charging business organizations, which is relevant, I think, insofar as many of us on the call are invested in protecting our own companies or our client companies from liability. And as we go on throughout the session this afternoon, I'm really going to focus on and speak from my experience with the DOJ guidance. And I do note, though, as I'm on this slide, that the Manhattan DA's guidance flows from and is certainly patterned upon the DOJ guidance, and I believe that to be true for many prosecuting agencies around the country, and it is certainly true for many of the federal enforcement agencies, SEC, and so on. Okay, next slide, please. What I've done on this slide is I've summarized the principles governing prosecution of business organizations from the DOJ guidance. And I'm going to run through them very quickly. Some of them are quite self-explanatory, but at the risk of being obvious, I think it's useful to run through them and to note what exactly is being addressed here. First is the nature and seriousness of the offense. You know, what kind of crime are we talking about here? Are there victims? Was there a serious impact on the larger community? Pervasiveness of the wrongdoing. Was this a rogue employee, or are we talking about wrongdoing or a culture that goes up to the top? Is the company rotten to the core? History of similar misconduct. And again, if you're looking at enforcement actions by FinCEN and other entities, you'll note that if there is a prior history, that will be noted expressly. I'm going to skip over the next three bullets for just a second and come back to them at the end and jump to collateral consequences. Let's call this the Arthur Anderson inquiry. I mean, it's really looking at the impact on investors, customers, the general community, and the company's very viability were it to be charged. This particular aspect of the guidance received a lot of press last year in wake of the BNP Paribas and Credit Suisse cases. Certainly led many to suggest that the DOJ doesn't need to worry so much about charging entities, that convictions are not necessarily fatal to their ongoing viability. That, frankly, is a subject for another CLE and another day, except I do want to note that when we're talking about financial institutions, perhaps the most regulated entity in the country, certainly one of the most regulated entities in the country, prosecutions, the prosecutor needs to work very, very closely with the bank's regulator or the financial institution's regulator. Convictions may lead to loss of charter. It's expressly spelled out in federal statutes. And a conviction for money laundering itself will trigger proceedings that could lead to loss of charter and loss of federal deposit insurance. So let's go back to disclosure, cooperation, and remedial actions, the three bullets sort of in the middle there. These concepts, these considerations, they are echoed time and time again. They are referenced in deferred and non-prosecution agreements, and they are referenced in DOJ policy in other areas. For example, earlier this month, the DOJ began a pilot program announced by its fraud section regarding Foreign Corrupt Practices Act enforcement. These considerations are echoed in the statements by regulators. They're referenced in their enforcement actions. These are constantly brought up, and they're sort of big ticket items, if you will, when it comes to considering should an enforcement action or prosecution be commenced. With respect to disclosure, there is, and I think everyone here on the line will recognize, a tension between a timely disclosure, and let's set aside for the moment what does timely actually mean, and the entity taking the time it needs to really get a handle on what happened so that it can relay accurate information to the government. Relaying accurate information is, of course, key, because relaying inaccurate information would potential obstruction and also undermines or certainly weakens any argument that the entity would have that it cooperated with the investigation. Remedial actions, again, self-explanatory. What did you do? What did the company do to fix the problem? But it gets into the question of, does the government need to spend its scarce resources on your company? Or can it trust that you really got it? You identified the problem, you've taken steps to deal with it, and that you can handle the problem on your own. Next slide, please.
And before that, secret word number 3, liability. L-I-A-B-I-L-I-T-Y. Liability is the third secret word. So, attendees, jot down liability, secret word number 3, to get your continuing education credit. Let's return to Kathleen, and by way of time, Kathleen, you have about, I'd say, 17 minutes or so to continue. So please go ahead.
Sure. The next slide talks about FinCEN and the culture of compliance. And culture of compliance is a rather vague concept that's often bandied about as a factor in prosecution and enforcement decision-making. In 2014, FinCEN, and for those who don't know, I'm sorry, I've used that term a couple of times, FinCEN is the Financial Crimes Enforcement Network. It is the entity charged with BSA enforcement. FinCEN released an advisory detailing what culture of compliance means, at least to it. And I've, again, summarized that memo on this slide, and I'll just run through some of these bullets quickly. Engage leadership. FinCEN wants demonstrable support for the compliance program. It wants to see demonstrable support. What exactly that means is going to depend on context. You know, having management's not only support, but their active buy-in and having compliances back is incredibly important to FinCEN in terms of evaluating culture. Revenue considerations are also one that FinCEN notes. It points out that your compliance officer needs to have the autonomy and the authority, again, you've heard this before, to carry out the AML function. And yes, that will cost money. We can argue about what exactly that means and how much money is required, which kind of bumps down to the adequate resources, provision of adequate resources to the compliance function. But that is something that FinCEN and others will evaluate when looking at, does this particular entity have a culture of compliance? Information sharing is something that FinCEN noted in this memo, and it relates back to what Simon had to say as well. I mean, it has come up repeatedly in recent enforcement actions where the regulators have noted that various functions within the entity were siloed, that information was siloed. The fraud section wasn't talking to AML. People investigating employee misconduct were not, talking to AML. Maybe there were extensive profiles done by marketing on the various clients, but again, that wasn't shared with the AML function. And FinCEN also noted that information about subpoenas that are being received, particularly government subpoenas triggering regulatory concerns, should be shared with the AML function. That a program should be tested really echoes the requirements of the statute itself. And the last bullet that leadership should understand how BSA data is used. It is, as I understand it, a real attempt to stress that the BSA's requirements, that compliance is not for compliance's sake only, that this data that is collected, the data that is reported pursuant to the BSA, serves as the basis for initiating investigations. It is used in furthering and developing investigations. It is used in prosecutions, and it is also used to identify patterns and trends. And understanding that this is not simply some rote exercise that you need to do, but it actually has meaning, can increase and contribute to the robust and healthy nature of one's compliance program. So next slide. This slide is it's DOJ's Bank Secrecy Act prosecutions against financial institutions, obviously, because that's who's governed by the BSA. I want to note, first of all, that these are net totals here, i.e. out-of-pocket expenditures. So, for example, if a FinCEN penalty was imposed, but it was deemed satisfied by the payment of a forfeiture to the DOJ, only the forfeiture is noted. So it's the total out-of-pocket here. And I also want to note that there's an asterisk on 2012 because that figure includes a deferred prosecution brought against a bank in which the bank was charged both with having an inadequate anti-money laundering program as well as with violations of the Trading with the Enemy Act, sanctions-related offenses. And it was a little bit difficult to pull all of that apart, so that simply the totals are noted there. Now, the purpose of this chart is really to highlight that while the number of cases brought by the DOJ has remained fairly constant, the penalties have greatly, dramatically, strikingly increased. And what I also want to note is that in nearly all of these cases, perhaps all of them, but certainly in nearly all, the charge was a failure. Let me rephrase that. In nearly all of these cases, the underlying charge was a failure to maintain an adequate money laundering program. That failure frequently manifested itself in a failure to file certain reports, which could have been and sometimes were separate charges. This harkens back to the risk-based comment, the risk-based policies that I mentioned a few slides ago. Because whether an entity has an adequate anti-money laundering program can be a somewhat subjective inquiry in my view. And it certainly has led to the criticism that the government is in fact regulating, telling entities what kinds of program it should have, that it's regulating through indictment. I'm quite certain that the enforcers would counter that in these cases that have been brought, the allegations were egregious. And I also want to note that in many, if not all of these, the inadequacies or the flaws in the money laundering program were discovered via another investigation. So in other words, the government was investigating something else, the Mexican cartels, this particular fraud, this Ponzi scheme, whatever it may be, and they noticed that money was moving in a certain way. They noticed patterns, which led them to question why the money was moving in that way. Why were those patterns happening, which then led them to investigate the financial institutions in question. So, next slide, please. This slide really is to show that this slide is totals, not necessarily amounts collected. So unlike the previous slide, it's the FinCEN penalties announced. And really the point of this slide is simply to note that FinCEN's enforcement priorities appear to have shifted over the past couple of years away from traditional depository institutions to other types of otherwise unregulated financial institutions. Next slide, please. So now we turn to individual liability, which is a very hot topic of late and is particularly close to compliance officers. And if there are any on the phone now, I'm sure you would agree. Next slide. So it's hot because pretty much everybody's jumping on the individual liability bandwagon. You've got all the regulators saying we're going to prosecute individuals when it's appropriate. You've got the New York State Department of Financial Services proposing regulations, which are a little bit scary. These regulations, which were announced late last year, are modeled on Sarbanes-Oxley, and they require the chief compliance officer or equivalent to certify that her financial or her institution has sufficient systems in place to detect and prevent improper transactions. There are criminal penalties for certifying if the certification is false or incorrect. And it's scary because as currently drafted, the regulations have no materiality standard. So unlike Sarbanes-Oxley, where New York State is proposing to have compliance officers not merely certify the existence of a program, but to certify the compliance with regulations and to certify its effectiveness, which is really putting compliance officers, to the extent they weren't already there, right in the center of that bullseye. Next slide, please. The Yates memo is a memorandum entitled Individual Accountability for Corporate Wrongdoing. It was issued last September by Deputy Attorney General Sally Yates, hence the name. A lot has been written about this memorandum and the policies that it spelled out. Essentially, the memorandum, its express purpose was to ensure that DOJ attorneys are consistent in their efforts to hold individuals accountable for corporate misconduct, and it applies to both criminal matters as well as civil enforcement matters. Next slide. The Yates memo outlines 6 key steps. Some of these are new, most of them are not, and those that are new may actually have very limited impact on the types of prosecutions that the DOJ brings. Let me just make a couple of points about them. The first bullet has received a lot of attention, and essentially what the DOJ is saying is that for a company to get any cooperation credit, any credit for cooperating, the company must disclose all relevant facts about individuals involved in the wrongdoing, all relevant facts, which is really quite vague and quite scary because we've got questions about, as I noted, when do you find those out? How far along is your investigation? What do you know? When do you know it? And there's a big concern that this requirement incentivizes entities to scapegoat. That remains to be seen, but it is a concern that is out there and it's certainly a little scary. The 4th and 5th bullets are really designed to keep pressure on prosecutors to address individual culpability. But I submit, and I think many agree, although not all, that the memorandum, although it's received quite a bit of press and quite a bit of attention, is unlikely to have a significant impact. And it's unlikely to have a significant impact for a couple of reasons. First, the suggestion that prosecutors weren't previously focused on individuals is mistaken. Prosecutors are pretty much always looking at individuals. And there have been prosecutions of individuals for Bank Secrecy Act violations. Setting aside your structuring, your prosecution of Smurfs and those sorts of things. We have, for example, the Miller case out of the Eastern District of Pennsylvania, where the bank president was prosecuted for failure to maintain an adequate AML program and for failure to file reports. So the call, that aside, the call for individual prosecutions has certainly been ratcheted up post-2008, but corporate wrongdoing, certainly the post-crisis corporate wrongdoing cases have involved very complicated facts, transactions that even the very sophisticated parties to these transactions could not explain. They involve entities with diffuse lines of responsibility and hierarchies, sometimes with international operations. And for anyone who's ever been involved in a treaty request for data or documents overseas, you can appreciate how very long that can take and how tedious the process is. So given those complications, given those obstacles, prosecutors have nevertheless got to identify the individual responsible for the wrongdoing, with a culpable state of mind, believe that they can prove that beyond a reasonable doubt, and they've got to do it all within the 5-year statute of limitations. Remember that companies will often agree to toll statute of limitations, but individuals seldom do. So I don't mean to be an apologist for government or for the lack of individual prosecutions or the perceived lack of individual prosecutions, but I do want to point out that these obstacles remain post-Yates memo, and they are very real obstacles to prosecution of individuals for Bank Secrecy Act violations. But that's the DOJ. The other regulators have talked about non-criminal enforcement. And if you look at FinCEN, for example, FinCEN has, over the past couple of years, voiced its intention to pursue individuals in appropriate cases. And half of the actions brought in 2014 and 1/3 of those in 2015 were indeed against individuals. And add to that, 2 of the actions brought against companies in 2015 originated from previous actions against individuals. So with the exception of 2011, in which FinCEN brought a series of actions against individuals operating MSBs, FinCEN had imposed penalties upon just 1 individual since 2005. So 2014 and 2015, therefore, represent a significant increase in the imposition of individual liability in FinCEN enforcement. That said, with a few exceptions, FinCEN's actions against these individuals have involved fairly small operations and resulted in relatively small fines against the owners of their respective entities, which I would suggest is perhaps a tacit acknowledgement of the difficulties in establishing individual liability in large organizations with, as I mentioned, diffuse hierarchies within the applicable statute of limitations, and so on and so forth. Next slide, please. So what can we take away from all of this? Next slide, please. What I've noted here, first, tone from the top. You know, what is that? Kathy, that's hardly a helpful suggestion. But I've noted it because it is actually important, but I acknowledge it can mean a lot of different things to different people and depend on context. But the fundamental question is whether the organization is taking compliance seriously. What are the repercussions for employees' failure to do so? Meaning, if a particular person or line of business refuses to work with compliance or to follow compliance rules or to toe the line, what are the repercussions? What is management's take on this? Does it affect performance evaluations? Does it affect compensation? How is management expressing its commitment to this, and how is it enforcing that commitment? Communication, and we've talked about this before. Does the entity have, or do you have procedures in place to facilitate discussions among all of your functions? Are you following the news? Are you, looking at, when you're the CEO of one of your big clients gets indicted, what are you doing? If you're getting government subpoenas, what are you doing? And remember what I noted before, that most of these BSA prosecutions against entities followed investigations, other investigations. So while particularly large financial organizations can't look at every subpoena that comes in, there should be some mechanism in place to evaluate them. Is this something that we need to look at? Are they looking at our own processes? Are they looking at a big client? Go back and look through your records. Were reports filed? If not, should they have been? What went wrong if a report should have been filed and it wasn't? And what are you doing then to follow up and fix the problem? That's related to the next bullet, which talks about the audits and the testing and following up on testing. You can't get an audit report that identifies weaknesses and simply put it in a drawer and not follow up on that. Both of those concepts really go to the idea of remedial action. What have you done once you identified the problem? What have you done to acknowledge that, yes, you appreciate this is important, yes, you're going to fix it, and no, the government does not need to come on in. As I mentioned before, remedial actions can go a very long way towards mitigating potential liability. So with that said, I think I'm at about 30 minutes. Thank you all for listening, and I look forward to your questions at the end of the program.
And thank you very much, Kathleen Nandon. Please stay with us for the Q&A. Remember, attendees, chat window, lower right-hand corner of your screen. You can submit a question at any time. We're going to turn to Professor William Burns next, but so as to not interrupt him, I'm going to issue the fourth secret word right now, and it's financial. F-I-N-A-N-C-I-A-L, financial, is today's fourth secret word. So for the attendees seeking continuing education credit, it's a good idea right now to jot down financial as secret word number 4. And now we're moving on to Professor Burns. Sir, you have your 30 minutes or so to present. Should take us to about 38 minutes past the hour. So Professor Burns, please go ahead.
Well, I always start off with a howdy from Texas A&M to any Aggies listening to this broadcast. We can move to the next slide, please. My colleagues for this webinar, Simon and Kathleen, have provided compliance officers a valuable insight for the management of data and internal anti-money laundering systems with a risk management approach to the relationship with FinCEN, as Kathleen was talking about, regulatory bodies. And I think Simon's presentation was just fascinating. It's kind of a different spin on it on the big data side. I'm going to pivot to the important topic for the anti-money laundering compliance officer, where the AML system overlaps with the new requirements for tax compliance systems. The tax compliance requirements in general, at least for today's discussion, we're going to look at tax self-certification forms that are required from each customer of a financial institution, whether it's located in the United States or in a foreign country jurisdiction. Over the next 30 minutes, I'll provide insight into the 5 topics on the slide before you. Instead of a group of slides, though, I've provided each delegate a 60-page detailed analysis of the overlapping AML and tax compliance issues. I encourage everyone to download that if you have not yet. That 60-page detailed analysis also includes an analysis of the W-8 self-certification forms, including suggested policy for your financial institutions. I've also looked for, provided suggested analysis for amending if you use a corresponding W-8 in a foreign jurisdiction. For those compliance officers, finally, that have a deeper interest in the topics I'm going to share today, please also see the link that I provided that has a free 115-page chapter on analyzing FATCA and the differences with the common reporting standards of the OECD. It's on my SSRN academic webpage. So my portion of today's webinar explores the impact of the Panama Papers on the compliance officer, as well as I'm going to offer guidance to navigate the intricacies of self-certification from the tax perspective. It is well understood that AML compliance now includes tax compliance. This relationship is explicitly understood by compliance officers because of the nearly 100 non-prosecution agreements against Swiss financial institutions over the past 5 years, and also because FATCA explicitly requires the overlapping use of the AML system for tax compliance purposes. It bears mentioning that the FBAR, FinCEN 101 form, is an anti-money laundering form, but its enforcement is by the IRS, as it has been for over a decade, and it has become the primary tool to punish non-tax compliance and obtain confiscation of assets related thereto, the overseas assets. That by itself means that anti-money laundering rules are being used to obtain tax compliance, where in the past it may have been tax compliance used to catch the criminal. So, to grossly simplify the impact of FATCA, the Foreign Account Tax Compliance Act, FATCA has pushed the burden of collection and validation of tax identification self-declarations for U.S. purposes on all financial institutions and financial firms, again, not just in the U.S., but of the 244 countries and their dependencies that are recognized by the United States Treasury. That is, pursuant to FATCA and its accompanying regulations, nearly all financial institutions, both U.S. and foreign ones, must obtain a signed tax self-declaration from the ultimate beneficial owners of their accounts. We would know those as the W-9s and the W-8 series. So foreign individuals must fill in and sign a Form W-8-BEN, and foreign entities, business associations, must fill in and sign a Form W-8-BEN-E. U.S. taxpayers, of course, you all should be familiar, sign the Form W-9. In addition to the FATCA requirement to collect signed tax self-certification forms, over 100 countries' governments have agreed to require a similar tax self-certification form be collected pursuant to the OECD-developed Common Reporting Standards. We use the acronym CRS, so I'll start using CRS in the rest of my presentation. In general, financial institutions are now combining the U.S. form requirements, the W-8 series, with those of the OECD series to create one form to collect all the information necessary to comply with both. But as Simon mentioned, often systems are disparate, divergent, and need to be brought together, which, again, he's already spoken about. So, ironically, the United States is not accepted to be liable to collect the same information that it has mandated that other countries collect. However, as a result of these now infamous Panama Papers, we're going to see a change this year in 2016. The change will come in the form of FinCEN, which Kathleen already spoke about, finalizing its 2014 proposed rule that U.S. financial institutions begin to collect the information on the ultimate beneficial owners of accounts controlled by or owned by corporations. That FinCEN final rule will require that U.S. financial institutions look through any amount of legal persons or relationships in between the account and final individual owner or owners, plural, that are identified. And that information that is collected must then be shared with U.S. Treasury. U.S. Treasury will in turn share that beneficial ownership information with foreign governments automatically. This soon-to-be enacted FinCEN rule has popular support in Congress, as evidenced by the February 26 proposed act, the Incorporation, Transparency, and Law Enforcement Assistance Act, that was proposed in both the House and the Senate and has popular support for both Democrats and Republicans. Moreover, the European Union is now also working to establish an international protocol that will allow foreign governments and even the public to access beneficial ownership information of business associations, as we call it in the U.S., but overseas, corporations. So 2016, it's a brave new, very transparent world for compliance officers of financial firms, and it's also a brave new world for managing AML risk. The Form W-8-BEN-E and its OECD equivalent at 12 pages can be quite difficult for many taxpayers and their representatives to complete, and correspondingly for the financial institution's compliance officer to validate. These forms are requiring substantial time of compliance officers and are leading to many mistakes. Let me put the numbers in perspective. Industry is currently estimating that 900 million tax self-certifications need collecting and validating by compliance officers around the world by 2018, when nearly all the old forms on file and in data systems will have expired. My two colleagues on this webinar are practitioners, and they're going to have a lot of very busy years ahead of them helping their clients manage only this area of compliance, not taking into account the other areas that Simon and Kathleen spoke about. So, as the renowned chef Emeril Lagasse of New Orleans says, let's take it up a notch. The United States Treasury has agreed with over 100 countries through something called intergovernmental agreements. We call them by acronym IGAs, that each country can have a variance in their definition for completing these required tax self-certification forms. These variances are contained not in the IGA itself, though, folks. They're contained in the Foreign Revenue Department's controlling guidances published in each country. So you just added a layer of a mind-boggling potential, at least as it stands right now, over 110 different definitions for, well, let me tell you how many terms we have to be aware of for the compliance officers in a moment. So since the original 10 pages of the year 2010 enactment of FATCA, the U.S. government has issued over 2,000 pages of regulations and guidance in the form of the regulations, FATCA notices, the instructions, the new W-8 series, the 112 new IGAs, so on and so forth. The amount of reading is even mind-boggling for me, and I'm an academic. So why are they so long? What do they contain? They contain newly 129 terms. So 129 new terms that can apply for the determination of how to and when are necessary to do these tax self-certification forms, what kind of information has to be collected, when is the due diligence applied, how the due diligence is applied, what criteria, on top of what I just previously mentioned, the potential variances in definitions of over 110 other countries right now. Okay, let me pivot to refer to the April release of the millions of documents known as the Panama Papers. At the heart of the Panama Papers is a Panamanian law firm and company service provider called Mossack Fonseca. The United States federal prosecutor of New York has already announced that he's launched several investigations based on that released data. But instead of, like today, focusing on Mossack Fonseca's alleged involvement in the client laundering of corruption or other criminal activities like the proceeds of the UK's Great Train Robbery, I want to discuss the tax compliance issues that will soon come to light as the investigations continue, those issues that impact compliance officers listening to this webinar. The United States is a self-reporting and assessment system whereby each year 150 million taxpayers fill in their 1040 with their worldwide income. It is reasonably estimated by various government sources, such as the State Department and the Treasury, that 10 million of these taxpayers have reporting obligations regarding their foreign income or their foreign accounts. Unfortunately, we know that less than 20% of Americans with international income or asset exposure are compliant with filing the dreaded but very simple FBAR form that requires reporting of signatory authority over accounts if the collective balance exceeds $10,000. Only approximately 800,000 FBARs were filed for the year 2012 for the group of potentially 10 million Americans. With so little FBAR reporting, it's no wonder that Congress and the IRS suspects that hundreds of billions of American foreign income goes unreported. Absent alternative information sources, the IRS doesn't have a scalable method to verify the 1040s and select for potential audit. This past week, I examined the year 2013 IRS tax statistics, which confirm the continuing low compliance tax rates. By example, U.S. persons only filed 470,000 returns claiming a foreign income tax exclusion. Foreign income exclusion. But the U.S. State Department estimates that more than 7 million U.S. persons reside overseas. So how is this possible? It means that less than 10% of Americans living overseas have employment income? Yeah, just not possible. So let me move on. I won't belabor the point further. But to say it is clear that there's substantial non-compliance remains. Swiss banks were prosecuted for sometimes assisting and sometimes just turning a blind eye to the beneficial owners of accounts who were not tax compliant with their filing obligations, including the FBAR and the Form 1040. Now with FATCA, all taxpayers with foreign assets must also file a new Form 8938. That form's been due since 2011, the last 4 years. That form asks different questions than the FBAR form, although they overlap in some respects. It is worth noting for the audience, in case some of y'all are thinking, this discussion's about tax compliance and doesn't apply to me. In 2005, the Supreme Court decision of Pasquantino established clear precedent that U.S. prosecutors may hold criminally liable the U.S. intermediary, by analogy, bank compliance officers, if a transaction evades not just U.S. tax, but foreign tax. So while I'm focusing on the U.S. tax reporting obligations, because most of the customers of our audience today are you're dealing with U.S. customers, financial institution compliance officers must also be aware of the foreign tax reporting obligations of their customers, as well as ensure proper capture and sharing of the requisite tax self-certification forms to be able to have that information shared with foreign tax authorities, which brings me to the tax self-certification forms, the W-8 series. In the infamous words of Ronald Reagan, trust but verify, the U.S. tax system is not just based upon self-reporting. U.S. Congress has deputized financial institutions through this FATCA to leverage their anti-money laundering systems to become information collectors and verification auditors. So I want to introduce 3 W-8 series benchmarks that have been collected by my FATCA research colleague, Hayden Perriman, who is the Director of Compliance for several Tier 1 financial institutions that I think everybody on this call is going to find interesting but shocking. Firstly, when the IRS qualified intermediary regime, known as the QI regime, was introduced in the early 2000s, it requires foreign financial institutions to report on their U.S. clients. Only 20% of W-8s on file at that time were fit for purpose. Based on our research by 2015, only 35% were fit for purpose. So in a decade, only 15% increase in fit for purpose of W-8s. That burden now falls on you, the compliance officer. Secondly, we know from interviews with large financial institutions, on average, it requires between 5 and 7 months for a financial institution to obtain a new W-8 from a pre-existing customer, and then only then can the validation process begin. And finally, the IRS estimates the time to complete the new W-8 BEN-E is 12 hours and 40 minutes of record keeping, and then another 8 hours on top of that for preparing and sending the form. That's 21 compliance hours before you can start your verification process. We must apply these metrics to the customer base for whom the compliance officer of a large financial institution must reach out to. Firstly, obtaining W-8s or W-9s or their equivalent substitutes under these IGAs I mentioned. Secondly, validating those against withholding certificates. And finally, thirdly, repeating this process for the 65% of the cases where the W-8 submissions turn out to be invalid because of wrong Social Security, wrong taxpayer identification number, incorrect foreign taxpayer identification number, misspelling of names, multiple problems go there. You can appreciate, I can appreciate the challenge y'all have as compliance officers. Amazingly, a 2015 large survey of by PayStream advisors found that 71% of respondents did not have an automated system for collecting, validating, and managing W-8 forms. I mean, if that information is even half correct, Simon's going to have an awful lot of business over the next couple of years. The IRS estimates that between 400 and 500,000 foreign financial institutions should have registered with FATCA to obtain their Global Intermediary Identification Number. We call that an acronym GIN, G-I-I-N. However, after 2 years of this being enforced, so far only 200,000 GINs have been applied for. So did the IRS simply overestimate? The answer is no. We know it's not, they didn't overestimate, because there's another identification number everyone on this call should be familiar with, your legal entity identifier number that you need to be able to play in the financial markets. There's over 436,000 LEIs, by acronym, that have been issued for 189,000 countries. So how can it be that financial institutions have registered for 436,000 LEIs, but less than 200,000 GINs in the exact same amount of time? Are financial institution compliance officers simply ignoring their tax compliance requirements? I don't know the answer to that. I just proffer it. Let me refer to one more data set, and then I'll come off the numbers. The same PayStream Advisors FATCA survey in 2015 found that compliance officers concluded that 61% of their payees were not foreign financial institutions, so no big deal about collecting this GIN. But that same survey found, when they drilled down, that 66% of the payees were businesses that accepted deposits, that managed financial assets, that acted as holding companies, and yada, yada. 66% of businesses were businesses that fall under the definition of foreign financial institution for FATCA compliance purposes. That means there is a total disconnect of what compliance officers believe to be their compliance obligation and what, under the law, their actual compliance obligation is. Consequently, I say, at least, that the majority of United States compliance officers have internally misclassified their foreign payees and thus have incorrect W-8 bennies on file. In which case you should call Kathleen to help you sort that problem out. Okay, let me move on, as my time is short. February 13th of last year, the OECD released its standard for automatic exchange of financial account information through what we now call the Common Reporting Standard. I mentioned the acronym CRS. The CRS calls on jurisdictions to obtain information from their financial institutions and automatically exchange that information between all jurisdictions. As I mentioned, the United States is not yet part of that agreement, but because of the Panama Papers, more likely than not, it will be, and I'll get to that in just a moment. So Part 1 of the OECD report gives an overview of the standard, and Part 2 contains the text of the Model Competent Authority Agreement, and importantly for you listening on this call, the due diligence standards that must be applied by compliance officers. Now, those due diligence standards are similar, but there are some variances between those global international standards that are law in every other country just about for the U.S. and the FATCA standards that you're more familiar with. Even Panama, of course, at the center point of the Panama Papers, has signed on to those standards, and it has re-verified that indeed it will be following those standards. The CRS starts with the premise of a fully reciprocal automatic exchange system for financial information of account holders, whereas FATCA started with this one-sided approach that only the United States would be receiving information. The main differences between the CRS and FATCA is that the CRS removes the United States tax specificities. The two most substantial ones are that the United States taxes national citizens as opposed to their residency, and so the CRS focuses on the definitions of residency and what is a resident and so forth. Obviously, FATCA looked at nationality. With my remaining minutes, let me now turn to the end of the 60-page analysis I provided you, and that's the FinCEN proposed rule of June 30th, 2014. Now, 1 month or 2 months ago, I'd have told you, it'll probably be another couple years before FinCEN puts that forward. But the Panama Papers have changed the game. Because of the Panama Papers, Congress has now put forward that proposed act, and that proposed act simply, at its essence, says, FinCEN, you better finalize your rule. So what is the new FinCEN rule? The new FinCEN rule will amend the existing Bank Secrecy Act regulations that have already been explained by Kathleen, so I won't go back into them. But they're going to amend them to help prevent the use of anonymous companies to launder the proceeds of illegal activity through the U.S. financial sector. The Panama Papers point out the widespread use of Delaware and Nevada companies in this regard. Ironically, not Panama companies, Delaware and Nevada companies. And many news organizations have for years reported that the U.S. is the last bastion of secrecy and opaqueness because the U.S. does not necessarily require banks or company service providers to know the ultimate beneficial owner of state-incorporated business associations. So the final rule will strengthen the customer due diligence, the CDD obligations of banks and other financial institutions such as brokers, broker-dealers, dealers in securities, mutual funds, futures merchants, commodities brokers, really all-encompassing. The proposed amendments will probably add a new requirement that these entities know and verify the identities of the natural persons, that is the real people in layman's speak, that are the ultimate beneficial owners who own or control the profits from the companies they service. Anybody familiar with the FBAR form will understand the difference between ownership and also control. So, FinCEN has stated that this information will be used to provide reciprocity under the FATCA IGAs that is for foreign governments. So, the amended required due diligence by U.S. financial institutions includes a new emphasis in the 4 core regular customer due diligence elements. Number 1, identify and verify the identity of customers. 2, identify and verify the beneficial owner of legal entity customers. 3, understand the nature and purpose of customer relationships. And finally, conduct ongoing monitoring to maintain and update customer information and to identify and report suspicious activities, which Kathleen already explained. The proposed requirement to identify and verify the identity of beneficial owners is addressed through the proposed new requirement to collect beneficial ownership information in a new FinCEN standardized format. That standardized format is at the very last page of the proposed rule. It's in your notes also, don't worry, there's a link to it. Pursuant to FATF standards and the CRS requirements I've already mentioned, U.S. financial institutions will have to identify and verify any individual who owns or controls 25% or more of a legal entity. The primary impact here regards the second element of the CDD that requires financial institutions to identify and verify the beneficial owners of their legal entity customers. The definition of beneficial owner proposed herein requires that the person identified as the beneficial owner be a natural person. So no longer can banks find another legal entity behind a structure and just report that legal entity. That's what's been going on up until now. And actually, except for people who took AML seriously, at least under the FinCEN rule, at least at first glance, it was probably legal. A financial institution must satisfy this requirement by obtaining, at the time a new account is opened, a standard self-certification form, such as your W-8, your W-9, but also this new FinCEN form I mentioned. Financial institutions will be required to verify the identity of beneficial owners consistent with their existing customer identification CIP practices. However, FinCEN has provided a loophole under the proposed rule because it does not require financial institutions to verify that the natural persons identified on the form are in fact the actual ultimate beneficial owners. Maybe that loophole will be closed when the final rule is put forward. The problem is that the Panamanian corporate service providers have been issuing powers of attorneys And those power of attorneys can act as the ultimate beneficial owners, and if the current loophole, the proposed rules, is kept in the final rule, those power of attorneys are still going to be used for nefarious purposes. So let me conclude just by looking at finally what information you, the compliance officer, must collect. So for legal entity customers, you'll have to find a natural person's name, date of birth, address, and for U.S. people, of course, social security number. But for foreign people, you're going to have to include their passport number, the country of issuance of the passport, and if somehow they don't have a passport, other very similar identification number. But in general, all the customers are going to have passports. Otherwise, how are they in the United States opening an account with you? So a financial institution must have a program in place to reasonably identify who the beneficial owner is. But again, I said that there's loopholes there. I'm going to wrap it up now because I've reached the end of my time in 1 minute. And so with this last comment, let me just point out that the European Union has already agreed that it will automatically start sharing corporate ultimate beneficial ownership information among the countries. This is different from CRS, different from FATCA. This is just a new regime that's going to be on place. It's not just for tax purposes. It's for a regime unto itself. I bring that up because more likely than not, they're going to ask the United States to become part of that regime. And if FinCEN does finalize this new rule this year, that will come to pass. So with that, let me bid adieu for my time, and let's turn it open to Q&A.
And thank you so much, Professor William Burns. Very fine job, all of our presentations today, Professor Burns, Kathleen Nandon, and Simon Moss. And we are going to get to our question and answer session momentarily, but first it's time for a secret word. Secret word number 5, rule. R-U-L-E, rule, is today's 5th secret word. Jot it down if you're an attendee seeking continuing education credit. Rule is secret word number 5. We have one more of the secret words for the attendees seeking credit. All right, panel, now it's time for the questions and answers, and these questions are being issued on a general basis, which means that anyone can feel free to just dive in and answer the question, especially if it's something that you touched on during your presentation. And the floor is open for all 3 members of the panel to weigh in should they decide that they would like to answer any of these questions. So let's ask question number 1. What reasonable alternatives do banks have besides de-risking by closing customer accounts? What reasonable alternatives do banks have besides de-risking by closing customer accounts? Who'd like to start with that?
Oh, I'll jump in on that one then. Well, obviously not to answer this in any twee way, but I think that the critical question that you have to answer is, how do I understand the risk of my clients? You know, de-risking based on limited data, based on the opacity of that limited data, is not really a model that is particularly useful. What you need to do is you need to focus at understanding the customer, the accounts, the behavior, the activities in a much more intuitive, much more transparent manner. We discussed during my section, add in multiple different data sources so you get a real understanding of the activities of the client, or you put markers in place so you can reconcile that client's behavior during the activities that the individual is going to have with your firm. I think that most firms are making decisions to mass close entire categories of clients, not just individual clients, not because they're risky, it's because they don't understand the risk. So my advice to answering that question is to look at the methodologies, the models, the data, and get a much crisper understanding of how you're going to deploy a risk management solution, an onboarding solution, and then at that point, you will have much more information at the tips of your fingers to make well-balanced and appropriate decisions.
Any other members of the panel have any thoughts on that?
William Burns here. I'll just jump in to add a comment that this issue is so critical. I was at a recent conference discussing with regulators dealing with South America and Latin America, and I find this information to be hard to believe, but it was stated by the regulators that Mexico only has one major correspondent account. Mexican banks only have one major correspondent trading account for their for the United States. It was stated. I mean, I challenged it. They said this is the way it is. I think it's interesting. And the point of that conference was that the United States regulators don't want just the itchy trigger finger of de-risking, and the FATF has also just published last month another de-risking study saying the answer isn't always just to close out entire regions from your trading block. It's actually damaging to the regions. The Caribbean is very afraid of this, and I think that I don't have an answer, but what I would suggest people do is really talk to their attorney, like Kathleen's firm, and have the attorney engage with the regulators to come up with mutually agreeable, comfort letters to allow this to go on, just like a marijuana business is having to do in Colorado, banks dealing with marijuana business. That's my suggestion.
Any other thoughts, or we'll move on to another question?
No, this is Kathy. I think you can move on. I would echo what my colleagues have mentioned. I mean, this has been a real problem, and it's received a lot of press lately as well. The idea of that de-risking by closing accounts is effectively pushing what would be on the radar under the radar and making it more difficult from a law enforcement perspective to monitor and track financial transactions.
And it's penalizing perfectly legitimate countries, businesses, and individuals, and leaving a boatload of money on the table for financial institutions that can get their risk modeling right.
Okay, panel, let's consider this scenario. I already have a TMS and case management system. We've invested time and money. Do you recommend ripping it out and replacing it? What do you think?
Well, by TMS, I think you mean transaction monitoring system. So that probably question probably directed at me. Oh, no. Transaction monitoring systems are awesome. These things are the backbone to the behavior detection of anti-money laundering programs. The case management systems are very good workflow engines that allow your analysts to understand where they are within the investigation process, and they manage documents. I mean, those are great assets. Our argument at Pneuron is that there's something missing. And what is missing is efficiency through that process. The transaction monitoring system is generating, as we said during my piece, tens of thousands of alerts, and the case management system is tracking them. The problem is analyzing all those alerts, particularly when you got a 95% false positive rate, is long, cumbersome, complex, and opaque. The way to solve it is to add something to it, and that's where Pneuron and other companies are working with the market to say we need to solve the process, time, and opacity issues within the AML program without having to reverse the very significant investments that have been put in place into the systems and processes of the past. So no, gosh, don't rip it out. That'd be silly.
Anybody else care to weigh in on that issue? All right, I have another question for the panel. Why is government now focusing on individual liability? Why is government now focusing on individual liability?
This is Kathy. I'm guessing that one's directed to me. I think, first of all, I'm going to disagree with the premise that the government is only now focusing on individual liability. As I mentioned, prosecutors are always looking at individuals. But I do agree that recent public statements are focusing attention on individual liability. And the reasons for that, at least as I see them, are several. First, there's a continued public outcry over the perceived lack of accountability for the financial crisis. The public wants to see someone in jail. and not just see big business pay a fine, consider that the cost of doing business, and go back to their old ways. So the statements from the regulators and from the DOJ are meant, I mean, at least in part to mollify the public, to address these public concerns. But I think also there's a recognition that, look, corporations, businesses, they act through their agents, right? So while a fine may or may not mean much to the business entity itself, the threat of jail means a lot to its employees. This really sends a message, and it's a way of encouraging business entities to get it together by encouraging their employees to enhance compliance.
Anybody else care to weigh in on that?
William Burns, I'll say that welcome to the world of tax compliance. Y'all are just catching up, because in the last 5 years, over 60 bankers have been put in prison for not having, or maybe conspiring with their clients to evade taxes, but for not having good compliance systems. And they're primarily foreign bankers. A couple have gotten off, not guilty verdicts, but they've had to go on through a full trial. And FATCA officers, who are compliance officers, have to sign under criminal perjury that they have FATCA compliance systems in place. That's the form to get the GIIN, the GIN form. That's all.
I have a question here. Let's direct it first to the professor. Are there any concrete plans for the U.S. to provide tax and financial information to foreign governments? Any concrete plans for the U.S. to provide tax and financial information to foreign governments?
Yeah, South America, in particular Brazil, a lot of Brazilian clients in Miami are deathly afraid that their governments are going to start receiving taxpayer identification from the United States. And so generally speaking, banks have been marketing that they will not, but it's not true. In fact, the United States Treasury released a Rev procedure in 2014 called Rev Proc 2014-64 that is specifically targeted and lists the countries that as of this year, Treasury will begin. That's this year, 2016, the Treasury is already now beginning to exchange taxpayer information to foreign countries. More countries are going to be added to the list as those countries basically come with technological protocols to be able to receive the information. The Treasury wants to give it to them now, but not all countries have a method to receive it. But as the CRS, OECD CRS system comes into full force next year, 2017, the OECD is setting up a system that will allow that information to be shared. The real question is, will the United States start pushing the ultimate beneficial owners of Delaware and Nevada companies to foreign countries' governments? And that's an open issue, but a really interesting one.
Would either of the other panel members, Simon or Kathleen, care to weigh in on that question?
Oh, no, Bill's the expert on that, certainly in where I'm concerned. All
right. We're going to have more questions for the panel, but first let's do the sixth and final of today's secret words, law. L-A-W, law, is secret word number 6, and I would encourage attendees seeking continuing education credit to right now jot down law as the sixth and final of the secret words, and thank you, everyone, for your attention to the secret words. All right, back to the panel. Here's another question being issued on a general basis. Anyone could just jump in. How do you measure culture of compliance? How do you measure culture of compliance?
This is Kathy. First, I'd say it's very hard. And there are some things that you simply can't measure. You know, and a lot of those things are kind of more obvious in hindsight. Was leadership sufficiently engaged, or were sufficient resources allocated? But there are some concrete things that you can look at to measure whether you've got at least some of the hallmarks of a culture of compliance. And first, it's a look at your chain of command, whether your chief compliance officer has access to the board, whether she can escalate matters if necessary. I mean, and of course, policies and procedures can be thwarted and subverted, but you know, are those policies and procedures, is that chain of command, is that access there in the first place? You can also look at testing. I mean, are you even doing it? Are you following up? Are you addressing your findings? How frequently you test is going to depend on your business. I mean, some do it, you know, some do it at all different intervals. I've seen some do it annually, some do it monthly, plus regular audits, and those who are well advised are reassessing after every new change in the business, after a new line of business or is acquired or sold or new products are brought on. And also whether you have, another way to measure it is whether you have in place a mechanism for information sharing. Again, as I mentioned, do you have a procedure in place for evaluating government subpoenas to go back and look at, you know, did we file, for example, did we file a SAR in this case? If we did, great, pat yourself on the back. Did you catch what was going on? If you didn't, why didn't you? How can your policy, could you have caught it? Could your software, could your monitoring system, could you have actually identified this issue? So it's a constant process of reevaluating, and the question isn't so much of like how successful you are on them, although that's certainly one element, but do you actually have these procedures in place?
Any other thoughts?
I have a comment on this, and I'd connect it to what Kathleen said earlier about the empowerment of the BSA officer and the AML officer. AML, unfortunately, for quite some time, has been seen as very much as a back office function. You know, just applying to regulatory requirements and, you know, just getting this stuff done. It isn't. And I think we're slowly beginning to see, both through, you know, individuals, people, bankers making decisions about, you know, where they will actually put their own money, as well as, you know, much more enforced and rigorous audit and regulatory enforcement. I think we're beginning to see a change in DNA. Within institutions, where they see reporting and transparency as not a back office function or a cost of doing business, but rather something that relates to their ethical brand profile. And we still got a decade of this evolution and maturation going, but I think that we will slowly begin to see what was an annoyance, and I'll be very honest with you, I believe that many people thought that, really becoming much more important. And Kathleen talked about tone from the top. I believe that is becoming significantly more prevalent, and I think that we're going to be beginning to see that trickle down, in which enforcement, transparency, and the support in training processes and communications within an organization begins to change. We've still got a while to go, but I think that post-2008, we've seen a real sea change in a lot of activities in that respect.
So then, panel, do you think the large penalties imposed by the Department of Justice upon financial institutions for BSA violations the past few years is an anomaly or evidence of a trend?
Well, I would continue what I just said, which I believe that it is a real trend. I hope so. I think it's appropriate.
I mean, my crystal ball doesn't work terribly well, but, you know, are a few years evidence of a trend? I think so, and I think so for a couple of reasons. One, I mean, sort of the conventional wisdom, you know, the word on the street is that the banks and financial institutions are simply going to remain on the government radar for quite some time. The politics of the time demand it. As I said, there's still press about how the banks got off easy, and I'm using air quotes for those who can't see me, after the crisis. There also seems to be an increased understanding, certainly within the public as well as within the businesses, how many moves, how it can be diverted to support illicit causes, how this happens. An understanding of this is growing, or at least it seems to me that it is, and that's triggered by a lot of what we're seeing in the papers, from the Panama Papers to reports about how ISIS is getting funding, et cetera, et cetera. Another thing I would note is that in 2011, DOJ created a special unit within its asset forfeiture and money laundering section, and that unit is called the Money Laundering and Bank Integrity Unit. Essentially, and I'm going to actually, I've just pulled up its website, The Money Laundering and Bank Integrity Unit investigates and prosecutes complex, multi-district, and international criminal cases involving financial institutions and individuals who violate the money laundering statutes, the Bank Secrecy Act, and other related statutes. The unit's prosecutions generally focus on three types of violators: financial institutions, including their officers, managers, employees, whose actions threaten the integrity of the individual institution or the wider financial system, and then they go on. I mean, I am going to go out on a limb and suggest that if the DOJ has actually created a unit just a few years ago to focus on money laundering investigations against financial institutions, if there's a unit out there whose mission is to find these issues, I submit that these issues will be found, and that we're going to see more of these cases.
Well, William here. I would say you haven't seen nothing yet, because we're talking about the U.S., but I spend most of my time overseas dealing with overseas regulators, and they're just starting, except for the UK. The UK is the one that's most recently, I know Simon must be British from his accent, so, the UK has learned recently from the US how to start imposing penalties and works well with the US regulators. But other countries are just starting to learn, and they're going to, in joint investigations, want their own piece of the pie, but also we're going to start seeing new anti-money laundering enforcement from the other 150 countries of the world who haven't been very strong on it, and they're going to follow the U.S. lead in terms of whether you see it as a revenue collection device or you see it as a punishment device. You know, you don't want to spend the money on your compliance program, then you're going to spend it on penalties. Whichever way you see it, there's going to be a lot more of it, and it doesn't matter whether it comes from the U.S. I think it will come from the U.S. also, as Kathleen said, but further, whatever you see in the U.S., double, triple that up for what you're going to see from overseas.
Al, I'm afraid we've run out of time, but we would like to thank our speakers and attendees for carving time out of busy schedules in helping to make this event a very successful one. Now, and as a reminder, if you're applying for continuing education credits, the survey is mandatory. Your state bars and boards require that we maintain a completed survey from each attendee. And now, ladies and gentlemen, this concludes our event for Anti-Money Laundering, Practical Guidance for Managing Regulatory Compliance in 2016. If you have a question for one of our speakers, send an email to info@theknowledgegroup.org, or you may contact each speaker individually using the information provided in your event's materials. And if you can't find that contact information, please send an information request via email to info@theknowledgegroup.org.